Yes, I'm Claire Johnson, president of MWA NorCal. I've known Michael for 40 years. We met at
Oh, we're not that old yet, Claire.
I know. Oh, okay, 4 years. We met at UC Berkeley as students and have been friends, our husbands and wives, and we're friends. Anyway, Michael has retired as a district attorney from after a decades-long career in a county that shall not be named. And he attended UC Berkeley and, like a lot of English majors, ended up getting a law degree from Hastings. Michael is currently writing a column for our MWA NorCal newsletter on various aspects of law. And if you have been not reading those articles, I suggest you do, because they're just fascinating. Anyway, Michael, please take it away.
Thank you, Claire. I'll go ahead and share my screen if I can here, and press the buttons that I'm supposed to press. And let me see if I can get my screen up. And hopefully you can all see my screen now. My presentation, I've been asked to talk about the Constitution and the mystery novel, and I'm going to subtitle that Keeping It Real for Fictional Detectives. As Claire has mentioned, I'm an assistant district attorney, retired, 35 years. And what gives me a lot of experience in talking about constitutional issues is that one of my main jobs towards the end of my career was litigating all these constitutional issues where criminal defendants and their lawyers try to undo all the hard work of our detectives by having it all excluded. And I've done hundreds upon hundreds of those motions. So when I talk today, I'm coming from a place of some experience. I've also done quite a few jury trials, including some murder trials. And from time to time, the DA gets involved in actually conducting investigations in criminal and sometimes civil, and I've done those as well. So I have a little bit of background in dealing with the legal issues that might affect a detective. I was reading a book by David Baldacci recently, actually, even though it's an older book, called Split Second. And it involves a retired Secret Service agent named Sean King, who is also a part-time cop and a full-time lawyer. And lo and behold, because it's a mystery novel, Sean gets caught up in a murder that we hope he didn't commit, but the police are not so sure. So the FBI and the US Marshal come to visit him at his house to ask him a few questions about why his gun happened to be the one that killed the victim. And this is the part I want to bring to your attention. And what Agent King said, or former Agent King says, just so you know, you haven't advised me of my rights, so I doubt anything I've said to you is admissible. The FBI agent says, you're not under arrest, so we're under no obligation to read you anything. And if called to testify, we can merely repeat what you said in our presence. King says, hearsay. And I don't think you'd be able to get it in because it's prejudicial. I'd get a mistrial in a heartbeat. US Marshal says, you don't practice criminal law, do you? No. Why? Because what you just said was a crock. Now, why am I talking to you today? I don't want somebody reading your mystery novels and at the end of them going, that was just a crock. So I'm going to be here to try and kind of keep you real. And let's see, hit the wrong button. So that's a good way to stay real. And the Constitution has a lot of impact on criminal investigations, particularly where they're conducted by police detectives. And it can affect the entire way an investigation is conducted, how they talk to people, where they talk to people, how they look for evidence. All of these factors are going to be gravely affected by the Constitution of the United States of America. And although private detectives aren't normally directly affected by it, they can be indirectly affected by it. So you have your police investigators, people like Harry Bosch, if you will, and Colombo, who are police detectives bound by the Constitution. But even our private detectives are Poirot, who's affected by Inspector Japp, or Philip Marlowe, who gets pushed around by every cop in Los Angeles, or even Miss Marple, who has to deal with Scotland Yard. are all going to be indirectly affected by the U.S. Constitution. The part of the Constitution that deals with police investigation comes from the Bill of Rights. And the Bill of Rights, of course, is the first 8 to 10 amendments of the United States Constitution. And those are primarily deal with criminal procedure. So that is the part of the Constitution we'll focus on today. I'm going to look at a few topics that do most strongly affect criminal investigations. The Fourth Amendment, which deals with searches, search warrants and the like. The Fifth Amendment, which talks about police interrogation, the right to remain silent, and double jeopardy. The Sixth Amendment, which has to do with the right to an attorney and the right to cross-examine and confront witnesses. And finally, Miranda, which is actually not in the Constitution, but which is an amalgam of two of the amendments, the Fourth and Fifth, or rather the Fifth and Sixth, which are the right to remain silent and the right to an attorney. Let's start off with what a police detective has to deal with. And I'm going to start with the one that everybody who ever watched any cheap cop show has ever seen a million times, and that's Miranda.
NYPD freeze!
NYPD, keep your hands where we can see them.
You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to an attorney.
If you cannot afford an attorney, one will be appointed for you. Why did you stop?
I'm done. You win.
Okay, we saw that. All right, so one of the things you notice in this particular clip, like in many of the shows that I've seen on TV and occasionally books that I've read, is the first thing the cops do is Mirandize the guy. He's not even handcuffed yet before they start. They draw their guns and they immediately start reading him his Miranda rights. That's one of the issues we'll discuss in just a minute. Here's another one.
The department was forced to drop the charges because you forgot to read him his Miranda rights. What possible reason is there for not doing the only thing you have to do when arresting someone?
I did read him his right. I did a version of that.
Do you even know the Miranda rights?
Yes.
Let's hear him then.
You got a lot of stuff to do.
Go ahead.
You got a lot of
You going anywhere, Schmidt? We got time.
I had a thing, but I could probably push it back.
Go ahead. It's 4 declamatory sentences followed by a question for a total of 57 words.
Okay. Look, it obviously starts with you have the right to remain silent. I know you've heard this before, and then I think it sounds something like well, the thing. Right. You have the right to remain an attorney.
Did you say that you have the right to be an attorney?
You do have the right to be an attorney if you want to.
Where were you?
I was chasing my purse.
Okay, so now we see a couple of other problems that come up when we look at the way Miranda is portrayed. Notice in this case that the supervisor is dressing these officers down for not giving the rights, for not knowing the rights, and now they have to dismiss the case. And you'd be surprised by the number of people who think that just because an officer doesn't Mirandize somebody, they're entitled to some kind of huge discount. The whole murder case goes away just because they didn't read him Miranda when they first arrested the guy. Well, there's several problems with that because what really happens in most of these cases is going to be something like this. This is what a real cop would do.
All right, Mr. DeBoer, I'm going to read to you your Miranda rights, okay?
Mm-hmm.
All right, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand each of these rights I have explained to you?
Yes.
Having these rights in mind, do you wish to talk to me now?
Yes.
Okay.
Okay. So notice a couple of things about that. First of all, the officer is not reciting it from memory. He's reading from a card. And the reality is that just about every police officer is going to carry a Miranda card in their wallet, or he might work for a department, or she might work for a department where they have forms that they use to fill out. And they'll read from the form, have the defendant initial and sign the form to make sure that it's clear. And the reason for that is pretty obvious. As you could see from our earlier officers, you can forget things. And that's just what every defense attorney's dream would be, is during a Miranda hearing to cross-examine a police officer and say, wait a minute, you did it from memory? Whereas when the officer says, no, I read it from this form word for word verbatim, that cuts down on the possibility of officer error and pretty much ends the discussion about whether the Miranda rights were really given. What does trigger advisement of the Miranda? Well, it isn't an arrest, as we saw already. The fact of the matter is, if they don't ask you any questions, the cops never have to give you your Miranda rights. There's no need, because it's asking questions that's the first trigger of Miranda. The police are asking you questions that are likely to incriminate you. So that is the first trigger. And the second trigger is a custodial setting. And what does that mean? Well, a custodial setting is a place where a reasonable person would feel like they couldn't leave. The police wouldn't let them leave. And some of that can be very clear. If you're sitting in a jail cell and they start asking you questions, you're not free to go. So your Miranda right has attached. If you're sitting in your own house and people come on in and say, hello, I'm a police officer, just had some questions for you. Come on, sit down, officer, have a cup of tea. Then you're not in custody and they don't have to Mirandize you whatsoever. Now, there's a lot of scenarios in between those two. For example, you could be questioned in a police station. The lady we just saw, for example, was questioned in a police station. They did Mirandize her. But suppose before they start the meeting, they say, you know, ma'am, you don't have to stay here. You're free to go at any time. We just want to ask you some questions. They don't have to Mirandize her as long as she thinks that she's free to go. Now, if she confesses to murder, they might change their mind. But it's her mindset as she's talking that matters, whether or not she's in custody. Also, somebody could be handcuffed in the back of a patrol car. They're not in jail, but they would be in a custodial setting and Miranda would be required. As I mentioned, arrest, it's not arrest alone that triggers the Miranda right. And that's because there's a lot of strategic considerations. And I'm going to talk about this a little bit more later, but one of the most important fundamental skills, in my experience, that cracks open most murder mysteries isn't necessarily forensics. It isn't necessarily DNA. It's good questioning of a witness. It's confessions. So every homicide detective worth her salt is going to do everything they can to make sure they get a confession. And if you tell somebody, hey, you have the right to an attorney. Hey, you have the right to an attorney. Hey, you have the right to an attorney about 10 times before the detective ever gets there, well, they might finally sink in and they might say, you know what? I think I will talk to an attorney after all. Now, as a result of that, what we want to leave the use of Miranda, the giving of the Miranda rights to the master artist. We've got an art going on here and we want the Rembrandt to give that. We don't want the finger painting kindergartner that we also call the cop on the street given Miranda rights, and then they sit around all day. So it's a very strategic consideration. And so you may find in real life that occasionally cops do Mirandize right away, but sophisticated cops that deal with sophisticated killers in big city environments are never going to do that. They're going to leave it for the homicide detective. You can have some pre-Miranda interaction with suspects. You can ask questions that are related to booking. What's your age? What's your name? That sort of thing. There's this thing called the public safety exception. So if you've got the Unabomber on your hands and you've arrested him and he just planted a bomb, you don't have to Mirandize him to say, where's the bomb and how long is the fuser time set for? You can go ahead and ask that question right off the top. Cops are allowed to have a little softening up, not allowed to have softening up. They are allowed to have a little conversation, a little banter before things get going, as long as it's truly innocent. However, softening up would be where you try and get the guy feeling good, try and get the guy feeling comfortable so that they will not invoke when you finally do Mirandize them. And that is not allowed. Now, when is somebody softening up and when are they not softening up? Well, that's the reason we have hearings and that's the reason lawyers get paid. The other thing that is not covered by Miranda is that the suspect just blurts something out. So he's sitting in the back of the patrol car and says, you know, she had a funny look on her face when I strangled her, and you didn't say anything as an officer. That is going to come in. You didn't ask a question. Miranda was not triggered. That statement would come in as a defendant's admission. What are the consequences? Well, if an officer does violate Miranda, you don't get a case dismissed. That's not one of the options. Not usually. There's enough relevant evidence elsewhere, the case will go on. But there is a consequence which can be problematic, and that is that the statement cannot be admissible at trial. And that's a problem. Suppose you've got a confession, beautiful confession, but the guy wasn't Mirandized, admits to absolutely everything, and the rest of your evidence is a little thin. Well, you have to tell the jury everything about the thin part of the evidence, and you can't use the statement if you're the prosecutor. And what that means is you might not even get it to the jury because the statement didn't come in and your evidence is so thin, the judge may say at the end of your presentation, hey, you don't have enough here, I'm dismissing this case. And the jury will never hear it. But if you have enough to get to the jury and the defendant does testify, you can impeach. And that means you can confront them with their statement and show that they're lying in their testimony. So if the defendant does take the stand and say, I never did it, you can use that un-Mirandized statement on the stand in cross-examination and say, well, wait a minute, didn't you tell the cops that you shot her 15 times in the head? And that statement's going to come in. Let's move on to the Fourth Amendment. And the Fourth Amendment has to deal with the reasonableness of search and seizures. It's the amendment that protects our privacy as citizens of the United States. And again, like the Fifth Amendment, the Fourth Amendment applies to governmental misconduct. So it's things that apply to police investigations most directly. One of the things that the essential tools of a police investigator is the search warrant. And that is what the Fourth Amendment requires, that every search be conducted pursuant to a warrant. The search warrant has certain legal standards that are set forth right in the Fourth Amendment. It has to be supported by what's called probable cause. Probable cause just means that a reasonable person, knowing what the officer knew at the time of the crime about the crime, or at the time of the investigation about the crime, would have a strong suspicion that the defendant was guilty. The search warrant has to specify where the search is going to take place. And there, of course, there's going to be some relation between where the search takes place and what the item is. So if, for example, you're looking for the murder weapon and the murder weapon is a car, you can't get a search warrant for somebody's house to look for a car inside the house, unless it's an unusual house. It also requires you to describe the item sought. So the officer has to particularly describe what kind of evidence is being sought. Now, as a practical matter, this isn't that much of an impediment because most times police officers are going to search a house. Most times they're looking for evidence that will be found in the house. And most times they have to prove that the evidence they found in the house belongs to the defendant and therefore that the house belongs to the defendant, which means they have to look for proof of ownership. It's called indicia. Some documents like utility bills or telephone bills, they're going to show that the defendant actually lives in that house. And to look for that item, you have to look everywhere, desks, under drawers, in the kitchen, in the coffee tin, you have to look everywhere. So as a practical matter, the police can pretty much search anywhere in a house if they phrase it properly when they get the search warrant signed. Search warrant targets include what are called real property, which is basically property you can sell by real estate, lands and buildings. Personal property, which is what we would just call items of everyday possession, things that you can move around, packages, suitcases, that kind of thing. Electronic information, business information, that sort of thing, telephone conversations or phone records. These things all require search warrants. The search warrant has different parts. It's got an affidavit, a search warrant itself, and the return. An affidavit, and here's a picture of one. Affidavit is something that's signed under oath, usually by the investigating detective. And that affidavit sets out the facts that would explain to the magistrate, to the judge, what it is that that makes him believe the defendant committed the murder and why he believes the evidence relating to that murder would be found in the house or wherever he's searching. That has to be signed under the penalty of perjury, and that gets submitted to the magistrate and read by the magistrate. If the magistrate agrees that there's probable cause, we move to the next part of the search warrant, which is the actual search warrant itself. It often looks something like this. And that warrant will be signed, and you can see there's a signature here at the bottom. ultimately it'll get filed in court. It's signed by the magistrate and it gives the authority to the police, and it has to be a police officer. Only a police officer can serve a warrant. They have the authority to go ahead and conduct that search. The last thing you need is the return, which means if the officer goes and serves a search warrant and finds some items, they have to return to the court with a list of the items that were actually found and seized. And that goes back to the court for the court's approval, and it's maintained. And that evidence then stays in the constructive custody of the court. It's going to sit in a locker room in the Oakland Police Department or some other agency, but it's actually in the court's constructive possession, and the police must maintain custody of it until and unless they get an order from a judge releasing that property. There's a cast of characters that we deal with, and if you want to touch a realism, of course, your detective is going to be that affiant, the person who swears under the penalty of perjury. You also have a magistrate, a judge, and I have had a lot of experience reviewing magistrates, hearing stories about magistrates, and those can be interesting characters to line your books with. I remember one real-life magistrate, and I'm not going to tell you her name or county, but she was notorious for receiving officers after 10 p.m. at night in her negligee on the kitchen table, offering them a glass of wine and some caviar while she reviewed the search warrant for signing. Because remember, a search warrant magistrate would be on duty 24 hours a day for typically a week, and they can get calls at all hours of the days and night. Unfortunately, murders are rarely arrested at 9 to 5. The last group of characters you're going to have are going to be the executing police officers. Again, as I say, it has to be the cops that execute a search warrant. And that's usually going to be a team led by a team leader. It's often the very same detective who wrote it, but it isn't always. There's a certain procedure that has to be followed in these search warrants. The first is called knock and announce, and that is designed to keep officers from getting shot when they go through the door, or keep homeowners from having heart attacks before the officers enter. So they're required to knock out loud and announce loudly that they are police officers serving a warrant, and they can demand admittance. They can wait for the person to answer the door. If there isn't a prompt answer, they can force open the door. Or if they hear the toilet flushing, they're probably going to force open the door. Another thing that and keep that in mind, you know, a subpoena, you can't kick down the door to get your evidence in a subpoena or any of these other techniques. But if you're a police officer with a warrant and the occupants refuse to let you in, you can kick the door down. We had a battering ram that we kept in our evidence room back when I was still working as a DA, and we called it the key, because we would use that key to open the door with a lawful search warrant. Another requirement is you have to leave an actual copy of the warrant itself, not the affidavit, but the warrant itself with the occupant of the house. And it's got to be the actual warrant. One thing I've read a lot about in detective fiction is where people will show a warrant that turns out to be a shopping list, but the unwitting homeowner has no idea. And so believing there's a warrant, they step aside and let the cops in. They conduct the search, which is now a warrantless search, get what they need and leave. Well, that would not work. You're required to show a copy of the warrant, and it would be, everything that was found would be suppressed, because that's completely 100% illegal. You can't trick people into thinking you have a warrant. You have to have a warrant. Once you get in, it's kind of interesting to note that there's going to be a designated finder. One of the police officers will be the designated finder. Maybe you have a team of 10 or 12 officers that are searching a house. And now I'm the DA and I need the evidence that was found in the various parts of the house. They're going to actually first be found by one officer, but it could be 10, 12 different officers. And I might have to subpoena the entire Moraga Police Department to testify in court, which would leave nobody on the street. So the common practice is to have one officer who is designated the finder of all evidence. And as the officers search, they would call that officer who would come and see the evidence in sight, take a picture of it, record it, and then when needed, when they need to be testify in court, it would be just that officer who would have to testify. There are exceptions to the search warrant requirement, and there are quite a few. I mentioned in my article, there's a 6-volume treatise that talks about exceptions to the Fourth Amendment search warrant requirement. I'm not going to go into all 6 volumes now, but tune in maybe later this afternoon, have a glass of wine, and I'll do it for you. The most common exception is the car exception, automobile exception. All you need to search a car is probable cause. The officer needs probable cause to believe that there's evidence of a felony inside that car, and they can search without a warrant. Plain view is another important exception. Plain view means if the officer is in a position that they have a right to be in, that they're legally and they're not trespassing, they didn't burglarize your house, and they see something they immediately recognize as evidence, they can seize that evidence. So if an officer is visiting your house and they happen to, you invite them in and they look over and see a knife on the kitchen floor, they don't have to get a warrant for that knife. They can grab that knife because they're in a lawful position to take possession of it. Another exception is exigent circumstances. If there's an emergency, burglary going on, they don't have to wait for a warrant to run into the house for a burglary. If they think somebody is seriously ill inside, they have good reason to believe there's somebody hurt or injured inside, they can go in without a warrant, and other situations like that. Another limited search that they conduct is called a pat search. So if an officer has a conversation with a suspect in the field and they have what's called articulable suspicion, in other words, they have a good reason that they can explain why they need to search somebody because they're afraid of having a weapon, they can search the outside of that person's clothing, not the inside, just to make sure that they're not armed with a deadly weapon. Lastly, you have a search incident to arrest. So if the officers arrest you, they have probable cause to arrest you, to take you in. They don't need a warrant to do that. They can search your entire person, your purse, anything that's immediately connected to you for evidence of a crime, and also to prevent you from smuggling contraband into the jail at the time of the arrest. The consequence for a Fourth Amendment violation is exclusion from evidence. And I can tell you as a former trial attorney, every trial prosecutor's worst nightmare. Because what do we want? We have to convict 12 people, 12 strangers from the community, selected almost at random, to believe beyond a reasonable doubt, without any reasonable question in their mind, that somebody's guilty of a crime. And that is extremely hard to do. And when you're a trial attorney, you want every ounce of evidence you can get your hands on. I've even seen prosecutors who suffer from what I call flea on the dog syndrome. They want to make, if their case is a dog, they want to give it more and more weight so that it looks nice and heavy. And they'll put anything on it, a nice stud collar, a harness, and they'll even add fleas. Well, you know, sometimes it just makes the whole case look mangy, frankly. But believe me, giving up evidence because it was excluded due to a Fourth Amendment error is our worst nightmare. I've done a lot of Fourth Amendment litigation, and these are some of the questions we have to deal with. The first question is, was there a search warrant? If an officer conducts a search and gets evidence pursuant to that search, then the burden of going forward, the burden of proving that the search was illegal is on the defendant, not on the people. But if there was no warrant, the burden is on the people to show that the search was a reasonable search. The other question is, does the suspect have a reasonable expectation of privacy in the place searched? And what that means is they have to have a personal expectation of privacy. If they don't have a personal expectation of privacy, then they cannot contest the search. So if you kill your next door neighbor, and then you leave the gun on your neighbor's house on the other side because both of you hate that neighbor and that barking dog, the gun is now at the neighbor's house. The cops go to the neighbor's house. They seize the gun from the neighbor's house. You have nothing to say about it. It's not your house. You don't have a reasonable expectation of privacy in your neighbor's house, even though you put the gun there. So the police can search that house, take that gun, and even if it's done illegally, you can't protest because you don't have a right to contest it. Final question is, was the officer's conduct reasonable? If the officer was acted without a warrant, we talked about some of those exceptions. Did they act in a reasonable way? Did they have good grounds for what they did? And if they acted reasonably, then the court's probably going to allow them to have conducted the search and keep it in. But if they were unreasonable, then the consequences will be that what they seize gets dismissed. Now, there is, of course, the shrunken head doctrine, which also comes into play. Now, I call it the shrunken head doctrine, and I am the only one that I know of who calls it the shrunken head doctrine. Here's how it works. You've got a jaywalker going across the street, and a police officer stops that jaywalker. It's going to give them a ticket. They don't have any ID. He pat searches them, goes into their pocket, and finds a wad of cocaine. Okay. We now go to a Fourth Amendment hearing. He gets arrested, charged for possession of cocaine. We go to a hearing, and the judge hears the evidence. And you want to know what? At least in the Bay Area, 9 judges out of 10 don't want to hear it. They're probably going to dismiss that case. All right, let's go to the same scenario, same hypothetical. We're crossing the street, stopped by an officer, does a pat search, and he finds a shrunken head, a real head, not a potato head. Then the police, there's a pretty good indication that the magistrate is going to say something different. The judge is going to say, well, wait a minute, let's not be so hasty. You know, jaywalkers are a problem here. And, you know, the officer acted reasonably in stopping him and pat searching for the head. So no judge will admit to that. And no published book will tell you that that happens, but that's the reality. And that's why I call it Mike O'Connor's shrunken head doctrine, because you'll never find any official recognition of that anywhere. Let's move on to the Fifth Amendment. And the Fifth Amendment has 2 things that we want to be concerned with primarily. The first of those is the double jeopardy clause, and the second is the right to remain silent. Let's start with the right to remain silent, which is more pressing and more relevant for most criminal investigations. Let me start there with a history, because this particular right has been enforced in different ways over the years. Before 1930, it was not that uncommon for the cops to use physical coercion to give somebody what they called the 5th degree, or the 3rd degree, pardon me, where they would, where they might even take out the rubber hoses, might punch somebody in the face, something like that, and get a confession out of them. That practice was exposed in a presidential commission in 1931 called the Wickersham Commission, and there was a public outrage when they realized that these confessions were basically being tortured out of people. So as of that time, because of the outrage, police agencies around the country started changing their practices, and beating a suspect for a confession was no longer the thing. But from 1931 to 1967, the police officers were still trying what they could to get confessions out of people, and they would use psychological techniques. They might have prolonged detention. They might threaten to arrest the wife. They might withhold food. They might do various things to try and get somebody feeling that they wanted to confess. And in 1967, the Miranda decision came down. That decision was written by Earl Warren, the former district attorney of Alameda County. And he exposed these practices, and he wrote the opinion that required the Miranda warning that you're all familiar with today. And it was only from 1967 that that Miranda warning has been required. But Miranda is only one part of the admissibility of a statement by a defendant, of a confession. It's the threshold question. But the other question is the statement truly voluntary? And if a statement is coerced or beaten out of a suspect, it becomes an involuntary statement. In other words, involuntary statements are not coming in because they're not considered reliable. And things that can have, it's pretty rare nowadays to see the cops beat a confession out of somebody. I've never seen it in 35 years. But I have seen cases where the cops threaten punishment. If you don't tell us what you know, you're going to get the death penalty. Okay, that's a threat that could expose the statement to being involuntary. They might keep somebody in custody too long. Here's one that's less obvious. They might promise leniency. Hey, tell us what you know, and I'll make sure that the DA doesn't charge you with this or that or the other. That's a promise of leniency. All of those are considered involuntary. They're coerced statements, and they are not allowed, and they would be thrown out by a court. There are acceptable techniques. One of those is deceit. Real murderers they don't play by the rules. That's why they killed somebody. They don't follow the rules. And if you're going to get after some of these guys, you might need to use a few legal tricks to get them talking. And one of them is deceit. Hey, if you weren't at that apartment that night, why did we find your DNA there? Well, the cop didn't find the DNA there, but the defendant doesn't know that. If the defendant's telling the truth, the presumption is they're going to say, well, it beats me. I don't have no idea. Somebody must have put it there. But many defendants will say, oh, now I remember. It was because I just went in to deliver a pizza. That's all. And then I immediately left and she was fine when I left. Okay, so that kind of deceit is considered acceptable. There are textbook techniques that can be useful, good cop, bad cop, as long as it doesn't get overbearing, those can be acceptable. And of course, artful questioning. And here, I think you could write an entire mystery novel that would be fascinating to me, because I've seen so many detectives use so many different kinds of questioning techniques on suspects over the years. And the trouble is, it wouldn't be a very quick read. It would be a long read. I mean, sometimes these questionings go on for hours. But I've seen one detective in particular, I remember, where there were 5 suspects, and he questioned all 5 of them. And one of them was the young kid who was one of the murderers. And with him, he became the loving father. Okay, son, he always called him son. So son, tell me how you got mixed up with these fellows. Hey, is that right, son? It would be very conciliatory, and the son confessed. The next guy was the planner with an ego like you wouldn't believe. Oh, I can't believe how wonderful. The planning was just great. It was clearly somebody really smart. It wasn't you. It was somebody really smart. Oh, yes, it was me. Let me show you how I planned it. So this guy confesses. He uses different techniques on each one of these defendants, all of these 5 defendants. And only on the last defendant, looked him in the eye. He tried all his techniques, and the last defendant said, I ain't saying nothing. I want my lawyer. So questioning had to stop, and that was the end of that. We did get that last defendant ultimately because I gave a deal to one of the other defendants to testify against him. Invocation. So what does that mean? Invocation is where the suspect says, I want my lawyer. What happens then? If a suspect says they want their lawyer, they're invoking their 5th Amendment right, their 6th Amendment right. All questioning has to stop. Cops cannot ask any more questions. Now, some cops will continue to ask questions. That's not really helpful, because then it's going to go from being a Miranda violation, which we told you before, you can still use that statement for impeachment. But it's going to go from that to being involuntary, very possibly. And then we can't use the statement at all. So it really isn't helpful. If the defendant invokes, we stop. The other consequence is that at trial, prosecutors can't comment on a defendant's failure to testify. I had a boss who kept telling me, when I was a brand new lawyer, I don't know why he thought this was funny, but he would come up to me and say, hey, Mike, I can hear you got a defendant on the stand. I got a defendant in court. You're in trial. Yes, that's right, Charlie. Well, did he testify? No, I don't think he's going to testify, Charlie. You make sure to tell that jury that if he was innocent, wild horses wouldn't drag him off that stand. And then he would laugh and go on his way. And I often thought I should just go ahead and do that, just to get at Charlie for teasing me so much, because the consequence of my commenting to a jury about a defendant's refusal to testify or refusal to talk to the police would probably be a mistrial or a reversal. And as I said, consequences of a 5th Amendment violation, where the statement is involuntary, is that it's not admissible, period, for any purpose, not to impeach, not to refresh memory, not for any purpose at all can you use that statement. 5th Amendment has also got a double jeopardy provision, and I'm just going to go over that really fast. Basically, in a nutshell, you can't be retried for the same crime or for a related crime under the double jeopardy provisions. And you probably all know that. And that's not normally going to come into a mystery novel unless you have a plot device, which somebody has already thought of. And that is a movie called Double Jeopardy. A woman is framed for her husband's murder. A woman framed for her husband's murder suspects he's still alive. She's already been prosecuted for the crime, so she can't be prosecuted again if she decides to kill him the second time. So let me warn you against using that as a plot device, because number one, it's already been done, and this was a pretty mediocre movie. And number two, it's also a bunch of it's a crock, right? Because the reality is, if the first conviction would be invalid and we would be able to prosecute her for the second conviction, we might give her a little credit for time served for the first sentence she served, but you don't get to kill somebody twice. Let's talk about the Sixth Amendment right to counsel. And the right to counsel is probably the most revered of all the constitutional rights and in American jurisprudence. And in particular, attorney-client privilege is especially protected. And I bring that up because occasionally you'll see in detective fiction and in real life where you'll have police officers arrange, or even DAs arrange, to overhear or wiretap or somehow record a conversation between an attorney and her client. And that simply cannot be done. The attorney-client privilege is sacrosanct in American law, and that would be called outrageous governmental misconduct, and it would lead to permanent dismissal of the criminal case. And I talked about reversal. If a case gets reversed, you can normally retry it. Sometimes you can't. Normally you can. But with outrageous conduct like this, it would be a permanent dismissal with no right for retrial. It would also lead to discipline of the offending cop, including possibly suspension, being fired, or even being prosecuted. You have a right to confront witnesses, and that comes from the Sixth Amendment. That doesn't really affect most police procedurals and most detectives. It's more of a courtroom drama kind of a thing. But the reason I want to cover that for just a minute is because of hearsay evidence. Hearsay gets a lot of bad rap. I read about it. I see it on television shows. I read about it in some detective novels. And it's always just hearsay. You can't use it. And the reality is hearsay evidence can be unreliable. It often is unreliable. And it doesn't mean that it's useless. It can be considered by the police when they're using search warrants. If they're going to arrest somebody, they can consider hearsay evidence. If the neighbor says, hey, that guy shot me, they can consider that evidence. It's hearsay, but they can consider it. Because hearsay, technically speaking, is considered an out-of-court statement. In other words, a statement made by somebody other than the witness in court that's being offered against a defendant. So at trial, hearsay evidence is inadmissible, not just because it's normally unreliable, but also because it denies the right to cross-examine and confront. You're cross-examining witness A, who tells you the statement of witness B, who's never going to take the witness stand. So the defendant never has the chance to cross-examine witness B, and you violated the confrontation right, the cross-examination right. Hearsay evidence is completely inadmissible unless one of the 20 billion exceptions to the hearsay rule applies. So hearsay comes in at trial all the time. Again, not really an issue for you, except for this. One important exception is the defendant's statement. A criminal defendant's statement is always going to come in as an exception at a criminal trial. So, and that's the case, especially if it's prejudicial. You often hear the attorneys say, hey, that can't come in, it's prejudicial. Well, of course it's prejudicial. Why do you think I'm introducing it? If it was harmless, I wouldn't need it. So being prejudicial is not a bar to admission. Let's move over now to the private detective. And of course, as we mentioned, the private detective is not a government agent normally. And so normally not subject to the 4th, 5th, 6th Amendment. Let's start by looking at about Miranda.
Can you just read me my rights, please? You have the right to remain silent. You have the right to speak to an attorney.
No, you missed a bit. Anything you say being used against you, that bit comes before the attorney.
I think it comes out.
No, before.
So you got the whole right to remain silent bit, and then...
And anything you say can be used against you.
Anything you say or do can be used against you in a court of law. And then you got the whole attorney bit, and then a bit about...
Court-appointed attorney.
They appoint you one if you broke.
Right. That sounds good.
That sound good to you? What kind of cops are you?
We're not cops, Eddie. We're private investigators.
Can you just read me my rights, please?
Okay, that came from King and Maxwell, a private detective show. Interestingly, that King, that's the star of that detective show, is the same King from our initial reading by the Badalci case that I started with. So you can see King hasn't learned very much about Miranda. And the reality is that private detectives don't need Miranda. As long as they don't make a statement involuntary, as long as they don't beat a confession out of somebody, they're not impacted by the Constitution in taking statements from defendants or talking to defendants. What about search warrants for private detectives? Well, I'll show you a good example of a search warrant for a private detective. Private detectives can't get search warrants. Now, you can break into a house, you can burglarize the house, you can seize the evidence. You can bring it to me, the DA, and I'll be delighted with it. I can use it because you're not a cop, you're not bound by the Fourth Amendment, and I'm not responsible for your private actions. So as long as you weren't acting as my agent, I get to use the evidence. I also don't really care what happens to you as a private detective, but things in fact can happen. Such as you break into somebody's house and you get a punch in the nose, or worse, you get shot. Keep in mind, in California, a homeowner has a presumptive right to kill somebody that breaks into their house. You could get sued. A lot of the privacy legislation that is involved around these cases allows people to sue occupants for trespass and other violations. You can get charged by the misdemeanor trespassing charges. By the way, in California, breaking and entering, there's no such crime. It's trespassing unless you break in with the intent of stealing. So if your private detective drops into somebody's house intending to steal their briefcase to get the evidence in it, then they're intending to commit a crime and they are guilty of a burglary and can be convicted of a felony. And of course, as with any misconduct by a private investigator, you could always lose a license. So just because I don't care as the DA doesn't mean you as an author or the private detective as a detective shouldn't care about following the rules. I want to now briefly talk about some of the other surveillance techniques that both cops and sometimes private detectives will use. And I'm going to go over those pretty quickly because they're complicated, but just to give you a flavor for it. Let's go in the right direction, first of all. Shadowing and tailing, you see that all the time. Shadowing and tailing is completely illegal. So shadowing is following somebody on foot, tailing somebody is in a car. And as long as the officer or the detective aren't trespassing somewhere, it's completely legal. And it does happen all the time. Police rarely have the resources for it, except in really big cases. But when they have the need for it, they know how to do it. The only thing to watch out for is sometimes at trial, the defense will object to a shadowing technique, and the technique that gets used might have to be disclosed. But anyway, that's not that big of a deal. Wiretapping. Now, that's something the police can do, but it's very, very rarely done. And they have to have a special warrant, not just an ordinary warrant. They have to have more than probable cause. They have to have a special magistrate who's trained to review them. And they're very limited in how they can conduct these things. And of course, private detectives can't use wiretaps at all. You can have electronic eavesdropping, bugs. You can bug somebody's house. You can put a bug in a martini, or a camera in a martini, or a nanny cam somewhere. You can certainly do those things, but those things are illegal. And they're forbidden by federal and state law. And under federal law, there are some exceptions. One of those is that law enforcement may record non-attorney conversations if they have the consent of one of the parties. And in prison, both local and state authorities can record conversations as long as they're non-attorney conversations. Remember earlier we said the attorney-client privilege is sacred, and even in jail you cannot record an attorney's conversation with a client. California has a stricter eavesdropping prohibition. In California, it's illegal to record a confidential communication. So if you get your cell phone going and you're talking to your boss and in confidence, hoping you'll have nice evidence that you can use in your lawsuit against him for wrongful termination, bad news. That's illegal in the state of California. You have to have the consent of both parties. And the other thing that you'll sometimes see detectives use, both police and private detectives, are GPS trackers on someone's cars. That's legal with a warrant in most states and illegal for private detectives in most states. covert GPS tracking of another person. Let's say you have an Apple AirTag, for example, and you want to put that in somebody's purse and see where they go. That is illegal in the state of California. You cannot do that. And some other states also make it illegal, but it's pretty new technology, and a lot of states haven't caught up, and it hasn't been banned yet by the federal government. So it's something to keep in mind. The consequences of illegal surveillance include being charged with felonies, because a lot of these types of covert surveillance are specifically criminalized by state and federal law. And of course, they also give the offended party the power to file a suit for big damages. And finally, the evidence is going to be inadmissible for all purposes. And all of this presupposes that, of course, you get caught. Now, I have no tolerance for a police officer who would ever act, caught or otherwise, illegally in any fashion. Your job is to uphold the law, not to break it. However, if a private eye never gets caught and I didn't know about it, well, what can I say? There's finally one more exception to all of these things, and it's what I like to call the Mike O'Connor Perry Mason exception. And you may have watched Perry Mason or something like it, and you'll see that Perry Mason will ask some ridiculous question that's completely unlawful, completely illegal. No way can it come in through the laws of evidence. You know, isn't it true you were wearing a blue hat and somebody told you you were a Martian and then they had a toasted? No, you can't ask that question. The way that they handle this in the Perry Mason cases is there'll be a proper objection saying, objection, you can't ask that question. And the judge says, well, it is unorthodox, but I'll allow it. And what that does is it gives the license to the writer. It says, it's a little wink. It says, I know what I'm doing here. I know you can't do that, but hey, cut me some slack. Keep your letters at home. Don't complain. Give me a little creative license here to go ahead and ask this question anyway. I know you can't do it. So that's another exception that writers can take advantage of, the Perry Mason exception. That's what I call it. All right, let's go back to where we started from, which is with our Split Second novel by David Baldacci. And let's go back to that conversation now that we've had this and just take a look at his statement and see why it is such a crock. King says, you haven't advised me on my rights, so I doubt anything I've said to you is admissible. Well, we now know that he's in his own house. They don't have to advise him of his rights. And he's not under arrest, as the FBI agent points out. So that hasn't been triggered in any case. It's admissible, even a Miranda violation, the evidence is admissible, at least to impeach. So he's wrong about that. The marshal says, well, if we're called to testify, we can repeat everything you just said to us. And he says, hearsay. And I don't really think you'd get it in because it's prejudicial. I'd get a mistrial and a heartbeat. And of course, we found out that it's not hearsay. Well, it is hearsay, but he would be a criminal defendant. And that means everything he said would come in as a hearsay exception, and there would be no mistrial. And of course, it's prejudicial. Like I said, why would I introduce evidence against a defendant if it wasn't prejudicial? And the marshal points out that what he said was a crock of shit. And that's where we get to the Perry Mason exception. Baldacci is now telling us, hey, I'm not the dumb one here. I know the rules. The dumb one is the character. So keep your cards and letters at home. No complaint from crotchety DAs who want to tell me I don't know my job. So that concludes my presentation, except for any questions we might have, if there are any. And I'll go ahead and stop sharing my screen here now.
There were actually a few questions.
Oh, great. Well, let me get rid of this screen thing. There we go.
Okay. Should I pop back in, or do you mind the disembodied voice from beyond?
However you prefer. I don't mind.
Okay, so let me just tell you, the first question came from John Jacobson. He asked, does the Miranda warning vary by jurisdiction?
No. Miranda is federally required, and it has to follow the format that I gave you, pretty much word for word.
Oh, a comment. Oh, and Chuck has it. So sorry, go ahead. There's more things popping in.
Anyway, that's no, it is a standard, pretty standard. I mean, wording can vary very slightly, but all those things must be covered, absolutely.
Okay, and Glenda Carroll asked, who was Miranda? What happened that the warning was required? How did this come about?
That's a good question, and I suggest you read the Miranda case from 1967. I'll send you a site. I honestly don't remember. I have read the Miranda case, and he's the name of the defendant, and I think it was a drug case, but to be honest, I can't remember what happened, except that he wasn't advised of his rights. And I remember that Justice Warren was outraged by it, but I'm sorry, I don't remember the facts.
That's okay. I've forgotten too. I think it was his Fifth and Sixth Amendment rights were was judged to be that they were not addressed properly as Fifth and Sixth. It might have been a kidnapping or a rape of a woman.
Yeah, I can't remember.
Took a long time to get to trial. So I was interested in you. Now there are lots of comments coming in that was great. Everybody's really enjoyed this. It's something that we've not touched on before, at least our group. So this is going to feed our writing. That's wonderful. Someone asked if you could share your email address again.
Sure.
You tell me, I'll type it in, or do you want to just put it in the chat?
I can do that. I'm looking, I remember off the top of my head because I have one I use for my professional. Here you go.
Okay, let me type that in there. Let's see if
it's maybe a little blurry. It's
a little
mtpoconnor@gmail.com. OCONNOR@gmail.com.
Okay, MTP.
M like Michael, T like Tom, P like Perry, O'Connor, OCONNOR@gmail.com.
Okay, there we go. And I actually was intrigued by your comment on hearsay. I think for us hearsay, although if it is not admissible, if fed to the proper party, like the prosecution, that can definitely feed a line of questioning, right?
Oh, absolutely. As I mentioned, a police officer can put it in their warrant. You can use it in your warrant. It's really a courtroom rule. Evidence is not admissible at court. That doesn't mean a cop can't use it or that I can't use it as a prosecutor.
Okay. Any other questions that are popping around?
I just wanted to make a comment, Michael, about how, all this is can be very cut and dried. But after all the years that I've known you and cases you've talked about, that they're really how prosecutors use these rules is also very fascinating. And it seems it can be very personality driven in a way, how they manipulate the rules to get convictions. I mean, do you feel that is a valid observation?
Well, you use the word manipulate.
I know, sorry. Okay. Yeah.
No, manipulating the rules. We're supposed to wear the white hats. Like I said,
Right.
A cop that doesn't tell the right line or a prosecutor, I have no patience for that. Manipulation is, if you'll pardon my saying so, and I hope there's nobody on the line that's offended, that's a defense trick. However, yeah, how we operate within those lines varies a great deal. And one of the great joys of trying a case, as opposed to the law in motion talking head type, Mr. Potato Head here, is the creativity that you can have, the theatrics that you can bring in, the way that you can use a mistake made by a defense lawyer or a defendant against them. But it starts by our following the rules pretty scrupulously.
Yeah, manipulate is the wrong word. Sorry about that. Yeah, but I mean, I'm just thinking of defense attorneys like Tony Serra, the real actors.
Sure.
Yeah.
Every good trial lawyer is at least a tolerable actor.
Yes. And there's something to be said for the way information unfolds, right? You don't want to just jump in with the kill shot right at the beginning. You want to sort of lead the jury into telling, much like we write a book, you want them to get the entire story, so that when you do give them that final piece, it comes together and they say, oh, then there's no other option for me but just to go with what you want me to say, because you just told me this great story.
Definitely there's an art, and no two prosecutors follow the same art of we start with an opening statement, which is an overview of the case. Honestly, if you want to see a good opening statement, if you want to see good lawyer training, the best movie I have ever seen for law is My Cousin Vinny, which is also a fun movie and kind of funny. It's amazing. And all the lawyer stuff that goes on, every little bit of that is 100% realistic. No crock anywhere in that whole movie. So I recommend that. But, and the prosecutor in that Cousin Vinny thing gives a pretty reasonable opening statement, pretty fair, pretty reasonable statement. But you're right, it's an art form. When do you give the big reveal? Do you start off with a bang? Do you end with a bang? How do you weave the facts in? All of these things is very artistically driven, just as it is for you writers when you tell your story.
Yeah.
Well, Michael alerted me to a prosecutor who was, she was the death penalty prosecutor, and she was conducting a trial that was just absolutely horrendous. And what struck me during her arguments was how it was absolutely like a novel. And she had this bang up reveal at the end where, I mean, I gasped. It was just, you know, she kept it till the very end, her big wow. And it was based on you know, she had some humor in there. This girl was abducted out of a park, and some employees were having a party and they were dressed up in bunny suits. And so everybody, you know, they have their ears on and it's kind of silly and everyone's, you know, standing around. And the vehicle in question of the guy who was convicted, thank God, he was driving a rather unique truck. And the very end of her arguments, she showed a picture of people in bunny suits and this very unusual green truck in the background. And that's how she finished her argument. And it was masterful. It was a novel right there. And it was such a horrible case. And I just felt like clapping. Of course I didn't, but and I was sitting right behind her parents. It was horrible. Yeah, it was, yeah. And needless to say, he was already in life, in prison for life, but it was just very, very well done. Amazing ending. Like a movie. It was literally like a movie. So
there's a lot of tedium in trials. And if you were to watch a trial for days and days, there'd be times when you'd be bored out of your mind. But
I wasn't bored for a second.
Drama and opening and closing statements by prosecutors should not be boring.
Yeah, I was on the edge of my seat. It was riveting, absolutely riveting. And the use of media, that's a whole nother subject, but yeah, it was just fascinating. Anyway, is that it for the questions, Lori?
I think so, yeah. I think.
Okay, well,
unless anyone else has anything else.
Anybody have another question?
Michael.
Okay. Well, I want to thank you, Michael. You know, dragging you in here on a Saturday in your suit and tie. You're so sweet. And I hope it, gives the members some food for thought. And please, Michael, read Michael's column in our newsletter, because he's been very generous with his time and giving us his articles on the law and the novel. So I think I'm going to stop recording and everybody can go on with their business, and I will see you at dinner.
All right. Thanks, everybody. Pleasure. I'm looking forward to reading from all of you in the future. Thank you.
So much.
Thank you, Lori, and thank you, Glenda. Thank you very much for your help. Okay, so how do I stop recording? Pause, stop.
Cloud.